Donald Trump has called out the National Guard to deploy in Los Angeles because of protests. Why? Because ICE is there rounding people up and the protesters don't like it. But does he have authority to do that? And what does California have to say? By the way, don't forget to go follow me on the Tube of You. I'm Legal Dad Chats over there. You can subscribe. Here's the statute that the Trump administration has used to support calling out the National Guard. Section 12406 of Title 10 of the United States Code. When can the President call into federal service members and units of the National Guard? Whenever the United States or any of the Commonwealths or possessions is invaded or in danger of invasion by a foreign nation. Well, that hasn't happened. 2, there is a rebellion or danger of a rebellion against the authority of the government or of the United States. Well, I suppose you can say there's some sort of rebellion, or the president is unable with the regular forces to execute the laws of the United States. In that case, the Guard can be called in such numbers as the president considers necessary to repel the invasion, suppress the rebellion, or execute the laws. But what about this? Orders for these purposes shall be issued through the governors of the states, or in the case of the District of Columbia, the commanding general of the National Guard of the District of Columbia. California has sued, saying that the requirements of that law have not been satisfied by the Trump administration, and specifically that the governor of the state, Gavin Newsom, was not consulted and did not call out the National Guard. What happens? Well, for now, the Guard is on the scene, and there's a lawsuit pending in federal court. Just like so many other things that have happened during this administration, it may be decided in the courts, and maybe ultimately the Supreme Court.